Mr. Kamar, thank you very much for your time. So now that you have had a response from Eskom who say that you can't sue them because of particular legislation, talk to us about who then are you going after?
Good morning to everybody in the studio. So Eskom did provide that response that we cannot sue them directly. However, I think the problem there was around the fact, what are we suing for? At no time did we say that load shedding isn't permissible. Eskom is in actual fact permitted to load shed, so we're very much on board with that. Eskom in itself, we're not going after Eskom because, number one, to go after Eskom, if we're getting them to repay the debt, we're actually going after taxpayers' money. And you'll agree with me that that doesn't make sense because inevitably, then we're just paying ourselves back. So what we have gone now about, we've sat around the table with our legal team, we've got counsel on board, and we've come up after the Zondo Commission, or at least part of it that's been made available to us. We now know that there's certain key role players, directors within the former board that has actually misappropriated the funds, and that is now who we are going after, because somebody obviously needs to be accountable for these funds or the load shedding that's happening now at the moment.
How many of these individual directors are you targeting, and are you able to give us a few names that you've identified?
Well, it's no secret who we're going after, and I'm very happy to actually disclose. There's no secret. I mean, the Zondo Commission has been quite clear about it. So, I mean, Mr. Geert Opperman, which was one of the managers in the coal department, he actually makes it clear in his testimony in the Zondo Commission where he says that Mr. Koko, which was back then the chairman, he pressurized him into actually going about getting the quality of coals that was totally cheap. There is Mr. Nagar that also said that, I mean, there was so much funds misappropriated or sent in the wrong sector, and there was about, I speak under correction, but there was a few 659 million rand that was paid irregularly out. There wasn't a signing off of it. So there's quite a bit of funds that, I mean, there's even Mr. Andre Pillay that said, Mr. Andre Pillay being the former treasurer, who said there was so much direct pressure put on him to sign or support a 25 billion rand deal or loan taken from a Chinese company, right? And I mean, it would have, there's no doubt about it, it would have put an Eskom in a burdensome situation. And it's important also to say here at this point that with this last transaction that happened, there was a 400 million rand kickback that was given as a deposit in a bank account in Hong Kong. So I mean, at the end of the day, we are saying at the beer attorney, somebody needs to be kept accountable for this. We can't just put the veil over our eyes for this one.
All right, talk to us about the amounts that you're suing for then. Have you calculated perhaps what each individual director will be liable for?
Okay, so just on that point, I think there's, just to break it down, there's two aspects that we're going after here, right? The one is certain people that obviously needs to be accountable, and that is what we have on the one side. So that's more a morality aspect behind that. Then we are going after also a delictual claim, and that's your question now to me, is how much monetary compensation are we going after, right? So before we can get to the monetary compensation, we need to prove that there's a delictual claim against these directors, and for that we need to actually prove that the directors either intentionally or negligently engaged in conduct that was wrongful, and by that the plaintiff either suffered some kind of economic loss, right? And so there's various, we have about 400 enterprises, commercial people that came on board and said that we can actually prove punitive damages. We can actually prove damages or substantive damages that was lost. So it's going to be on a case-by-case basis. Initially, we were thinking of a class action. The hurdle with the class action, however, is that we're obviously going to have to identify the class, and at the end of the day, the class that suffered here is the entire South Africa. So in that sense, a class action was not the most viable route, because on the one hand, you're going to have a massive enterprise that's going to say they suffered a few 100 million rands, and on the other hand, you're going to have somebody that said, because of Eskom, I couldn't make a cup of tea. So we had to make the decision, and an informed decision on what we're actually doing, what we're going to do. So where we're standing now, it's any business that can actually prove that they suffered a substantial loss. We're inviting them to come on board, and obviously once they make contact with us, we'll inform them what's the process further from here.
All right. Just in closing, therefore, how many organizations would you say you represent right now? And more importantly, do you have a strong, winnable case?
At the moment, where I can easily say off the top of my head, there's about 150 organizations that literally said, we must please go ahead. They're backing us 100%. Whether the case is 100%, in my personal belief, I do think we have quite a solid case. We have discussed this at length with our counsel. We have a legal opinion on it also from some top-notch advocates counsel. So, I mean, nothing's been sucked here. It's things that's been sat around the table. It's been discussed at length, and from where I'm sitting, we're ready to go.
All right. Thank you very much for your time. That is the representative, I should say, from the De Beers attorneys, Mr. Abdurraf Kamar.